Chapter 4, Search Procedure and Strategy.
Welcome to your Euro Patent Brief journey with Baris Atalay. Today we're diving into the European search procedure and strategy as outlined in the EPO Guidelines. Searching for prior art is a critical step in the patent process, and understanding how it works can help you navigate the system more effectively. This topic may seem complex, but don't worry. I'll guide you through every detail in a structured, interactive way. Let's get started.
Part 1. What happens before the search?
Before a European search report is prepared, the process begins with a pre-search algorithm. This system generates a list of documents that the search division will examine. A key point: once the search division starts, a marker is created in the file. Why does this matter? Because if the application is withdrawn, refused, or deemed withdrawn, this date determines whether the search fee can be refunded. Now let's break this down further.
1.1. Understanding the application.
The search division first analyzes the application to understand what problem the invention solves, what inventive concept leads to the solution, what essential features are in the claims, what effects the invention achieves. If some technical features appear crucial to solving the problem, but they are not included in the claims, the search division still considers them during the search.
1.2. Checking for formal issues.
Next, the search division looks for formal deficiencies, errors that might have been overlooked earlier. If they find any, they inform the receiving section or examining division. Some common formal deficiencies include missing sequence listings for biological inventions, incorrect page numbering, drawings placed inside the claims, alterations or erasures that affect authenticity. The division also checks if the application contains prohibited content, such as statements that go against public order, disparaging remarks about competitors. If the application involves biological material, the search division verifies whether the depository institution and accession number are correctly provided. Now let's move on to a crucial part of the process: the documents cited in the application.
Part 2. Documents cited by the applicant.
When an application claims priority, the applicant must submit previous search results if available. The search division reviews these documents carefully. If a cited document is unavailable but seems essential to understanding the invention, the search division will request it under Rule 63. The applicant has two options: submit the document, argue why the document isn't needed for a meaningful search. If the document is not provided in time, the search division restricts the search and issues a partial search report. Now let's discuss search strategy, how the division approaches the search itself.
Part 3. Search strategy.
Once the search division understands the invention, they plan their search strategy. This involves selecting keywords, choosing the most relevant technical classifications, checking whether any subject matter is unpatentable, assessing whether the invention lacks unity. If an application is so unclear that a meaningful search is impossible, the search division issues a Rule 63 declaration explaining why.
3.1. How the search is conducted.
The search division consults patent databases, scientific literature, other classification schemes like the Japanese FI system, colleagues in related technical fields. They refine their search as they go, revising keywords or technical classifications if necessary. But how do they decide which documents are relevant? Part 4. Identifying relevant documents. The search division looks for documents that affect novelty, inventive step. They also note other useful documents, such as conflicting patents, documents that challenge priority claims, background technology. A key principle: the search stops once the likelihood of finding more relevant documents is low. Now let's talk about what happens after the search is complete.
Part 5. After the search.
Once the search is finished, the search division selects the most relevant documents for the search report, ensures no unnecessary citations. If multiple documents say the same thing, they cite only one, uses the most convenient language for citations, handles late discovered documents. If new documents appear later, they can be used during examination. Corrects errors. If mistakes are found before publication, they issue a corrected search report. And that's how the European patent search procedure works from start to finish.
Recap. Let's reflect.
Let's take a moment here. Pause and breathe. Today we explored how European search procedures work. You learned how the search starts and why timing matters, how the search division analyzes an application, how they check for formal issues and missing documents, how they plan and conduct searches, how relevant documents are identified, what happens after the search is complete. This is a crucial part of the patenting process, and understanding it will help you anticipate how your application will be examined. In the next session, we'll dive further into search procedure. Thank you for learning with me, and I'll see you in the next session.